Imagine this scenario. Your neighbor decides to build a massive custom reservoir on his property.
Right.
Like millions of gallons of water held back by a dam just sitting right next to your land.
Sounds terrifying.
Yeah, totally. And then one night, a stranger sneaks onto the property, maliciously blows up the dam, and literally floods your entire house. The damage is catastrophic.
Oh, wow.
So who pays for it? Does the neighbor have to pay you, even though, a stranger caused the explosion?
It's a great question.
Hmm.
And the answer is actually hiding in one of the most bizarre specific rules in tort law.
Which is exactly the kind of puzzle you have to solve on the SQE.
It is, yeah.
Yeah.
I mean, it is the ultimate diagnostic test because the solicitor's qualifying examination isn't about simply reciting rules.
Right, no one cares if you can just quote a textbook.
Exactly. It's about looking at that flooded house or a broken leg or a ruined business and spotting the hidden clues in the fact pattern because a single detail can completely change the outcome.
Welcome back to part 2 of our tort law deep dive. This is entirely customized for you, the SQE revision candidate.
Glad to be back.
Our mission today is to decode these complex rules into, recognizable fact patterns. So when you're sitting in that exam hall reading a scenario, the triggers just jump right off the page.
That's the goal.
Okay, let's unpack this. Today, we are wading into the really tricky stuff. We've got occupiers liability, defective products, breach of statutory duty, nuisance, and the infamous case of Rylands v. Fletcher.
It's a heavy lineup. But the overarching strategy for all of these topics is to basically ask 2 questions before you do anything else.
Okay, what are they?
Who is the claimant and what caused the harm?
Who and what?
Right. Because rote memorization fails when exam questions blend, like 3 different torts together. If you can identify the status of the person and the source of the danger, the correct area of law naturally reveals itself.
That makes sense. I mean, every tort has a scene of the crime, right? So let's start with the ground beneath your feet. Because the most common physical location for an injury is simply someone else's premises.
Absolutely.
The classic example is a supermarket. You are walking down aisle 4, you slip on a dangerously wet floor, and you injure your back.
Ouch.
Right? And the immediate reflexive thought for most people is, negligence. I'm going to sue for negligence.
And, well, that instinct makes sense in the real world. But in the context of the SQE, if the injury happens because of the physical condition or the state of the premises. Exactly. Your analytical brain needs to pivot immediately to occupiers liability. The law treats the physical space itself very differently than just a random careless act.
Okay, so the trigger is the state of the premises. But let me ask a foundational question here because I feel like this is a massive exam trap.
Go for it.
Does occupier just mean the owner of the building? Like, if I slip, am I automatically suing the person whose name is on the deed?
Oh, that is one of the most common exam traps, yeah. Occupier does not automatically mean owner.
Okay.
The law defines an occupier as whoever has sufficient control over the premises.
Sufficient control.
Right. It could be an owner in possession, sure. But it could also be a commercial tenant leasing the building, or even like an independent contractor running a construction site.
Oh, I see.
The defining question the courts really ask is, who has the power to admit or exclude people? And who is managing the safety of the space?
So it's less about whose name is on the deed and more about who is throwing the party. Like, who is actually managing the space and the people in it.
That's a great way to think about it.
So once we know who the occupier is, we have to look at the claimant. And there are 2 crucial statutes here, right, depending on who actually got hurt.
Yes.
We have the Occupiers Liability Act, 1957, and the Occupiers Liability Act, 1984.
That's right.
Just thinking out loud here, if 1957 deals with people allowed on the property, I'm going to lock that in my head as 57 means you're invited.
I like that.
And if 1984 is the other group, then, 84 means you're through the fence.
That is a highly effective mental shorthand for the exam, honestly. Keep that in mind. The 1957 Act deals with lawful visitors, so people who have express or implied permission to be there.
Like customers, social guests, the postman.
Exactly. The occupier owes them a common duty of care. But you have to listen to the statutory wording carefully here.
Okay.
The duty is to take such care as is reasonable in all the circumstances, to see that the visitor is reasonably safe for the purposes for which they were invited.
Reasonably safe. Okay, so not a hermetically sealed bubble of absolute safety.
Precisely. It does not mean guaranteeing the visitor will never be harmed.
Right.
If that supermarket knew the floor was dangerously wet, had no cleaning logs, and just left it for hours, That strongly suggests a breach.
Obviously.
But if they had a rigorous, reasonable inspection system in place and a customer slipped on a puddle of juice that had been spilled like 30 seconds prior, the supermarket likely isn't in breach.
Wow, okay.
The legal question isn't just, was there a danger? It's, did the occupier take reasonable care?
That makes a lot of sense. So let's talk about the you're through the fence crowd. Trespassers under the 1984 Act.
Right. And what's fascinating here is the historical evolution.
Oh.
Yeah. For a long time, the law offered virtually no protection to trespassers. They were seen almost as outlaws.
Like enter at your own risk, basically.
Pretty much. But in the mid-20th century, society's views shifted, particularly regarding child trespassers, who were unfortunately wandering onto electrified railway lines.
Oh, wow. Yeah, that changes things.
The courts and Parliament realized a basic duty of humanity was required. So the 1984 Act was created, but, and this is key for your revision, the duty is much narrower than the 1957 Act.
Narrower how? Do they just have to put up a warning sign or something?
Well, an occupier doesn't owe a general duty to make the whole place reasonably safe for a trespasser. That would be too much. Instead, if they know about a specific danger and know a trespasser might come near it, they must take reasonable care to see that the trespasser does not suffer personal injury by reason of that specific danger.
Personal injury. Okay, so 1957 for visitors is make the visit reasonably safe. And 1984 for trespassers is take reasonable care against a specific danger.
Yes.
And you really emphasized personal injury there. So if a trespasser ruins their, 2,000-pound designer watch while climbing over your barbed wire fence, they can't claim for the watch under the 84 Act.
They cannot. The 1984 Act covers personal injury only, not property damage.
Got it.
And keep an eye out for special caveats in the fact patterns, too.
Like what?
Well, the law explicitly expects children to be less careful than adults.
Naturally.
Right. So if a scenario involves a child in an alluring but obvious danger, think of like a bright toxic berry bush, the occupier must do significantly more to prevent harm than they would for a full-grown adult.
That makes sense. What about professionals?
Conversely, for skilled visitors, like an electrician you hire to fix some wiring, the occupier can generally expect them to appreciate and guard against the ordinary risks of their own specialized trade.
Okay, let me throw a wrench into all of this.
All right.
What if the landlord isn't the occupier? Let's say a tenant is renting a house. So the tenant is the one throwing the party. They have control.
Right.
But the staircase collapses because the wood was rotting deep inside the structure. The tenant is badly hurt. Is the landlord just completely immune because they aren't technically the occupier?
They are not immune, no. But you have to look outside the Occupiers Liability Acts for this.
Oh, okay. Where do we look?
This brings in the Defective Premises Act 1972. The mechanism here is obligation.
Obligation.
Right. If a landlord has a legal obligation or reserved right to repair the property under the lease, and a defect falling within that obligation causes injury or property damage, the landlord can owe a duty of care.
Okay, so your SQE trigger is a chain. Landlord plus repairing obligation plus defect plus injury.
Exactly. Connect those links.
Okay, so we've covered getting hurt by the physical space. You know, the floor, the stairs, the fence. Let's shift gears.
Let's do it.
What happens when the danger isn't the building you walked into, but the thing you brought home from it? Like, say you buy a defective toaster.
Now we are moving from the land to the goods. Product liability.
Not good liability.
If you plug in a toaster and it malfunctions, starting a fire that injures you, there are multiple avenues for a claim. You could sue for breach of contract, you could sue in the tort of negligence, or you could claim under the Consumer Protection Act 1987, which we call the CPA.
Okay, so let's use a classic example. You buy a kettle, it's defective, your friend comes over to your house, boils water for tea, and the kettle explodes in their face.
Terrible tea party.
The worst.
Yeah.
And your friend didn't buy the kettle. They have no privity of contract, meaning they don't have a direct legal relationship with the shop that sold it.
Right.
So a contract claim is totally out, but they can still sue the manufacturer in ordinary negligence, right?
They can. Under ordinary negligence, ever since the famous snail in the ginger beer case.
Oh, Donahue v. Stevenson.
Exactly. A manufacturer owes a duty of care to the ultimate consumer. But negligence requires proving fault. The injured friend would have to prove exactly how a manufacturer breached their duty on a complex assembly line, halfway across the world, perhaps months or years ago.
That sounds impossible.
For a normal consumer, proving the chain of fault is an incredibly steep, expensive, uphill battle.
Which is exactly why Parliament stepped in with the Consumer Protection Act 1987. This is a major trigger for the exam, guys. The CPA creates a regime of strict liability.
Yes. And we need to pause and dissect this because the SQE examiners love to test the boundaries of strict liability. Strict liability does not mean absolute liability.
Wait, strict liability, does that mean if I manufacture like a totally normal stepladder and a consumer uses it to swat a bee, loses their balance, falls, and breaks their leg?
Am I buying them a new house?
No, definitely not. Doesn't strict mean I just have to pay for literally everything that involves my product?
It sounds like it, I know, but no. Strict liability simply removes the burden of proving fault.
Oh, okay.
You don't have to show how the manufacturer messed up the assembly line, but you still absolutely have to prove that there was a defect in the product itself. If someone misuses a perfectly good ladder, there is no defect, and therefore no liability.
How does the law actually define a defect then?
It uses an expectation test.
Expectation test.
The statute asks whether the safety of the product was not such as people generally were entitled to expect.
Okay.
So the courts look at all the circumstances, how the product was marketed, the instructions, the warnings on the box. If a ladder is marketed as suitable for heavy-duty household use and a consumer uses it normally to change a light bulb and the metal simply shears in half,
Then it failed the expectation.
exactly. That is a failure of expectation. That is a defect.
So if the fact pattern shows a product used as intended, it breaks, and someone is hurt, think CPA 1987. But there are strict limitations on what you can claim financially, right?
Yes, there are.
The CPA covers death and personal injury, and it covers damage to private property, but it does not cover pure economic loss.
That's a critical distinction.
Let's ground that term for a second. Pure economic loss means financial damage that doesn't stem from a physical injury or property damage, right? Like if the broken toaster means I can't run my pop-up breakfast business for a week and I lose profits.
That is a perfect definition of pure economic loss, and the CPA will not compensate you for it.
Good to know.
Furthermore, you cannot use the CPA just to get a refund for the broken product itself. The Act is not a warranty replacement service for a bad toaster.
Right, go to customer service for that.
Exactly. Finally, there is a specific statutory threshold for property damage under the CPA. It's 275 cans. If the damage to your other private property doesn't exceed 275 cans, the CPA won't entertain the property damage claim.
Okay, so CPA equals person plus private property over 275 fives. Got it. Now, what about defenses? Manufacturers must have some way to protect themselves, especially with, cutting-edge technology.
This raises an important question about how the law balances consumer safety with the need for technological innovation. The most heavily tested defense on the exam is the state-of-the-art defense.
State-of-the-art, what does that actually look like in practice?
It essentially argues that the scientific and technical knowledge available in the world at the time the product was manufactured was simply not advanced enough for any producer to reasonably discover the defect.
Oh, wow. So they literally couldn't have known.
Right. Think about early historical cases involving medical devices or pharmaceuticals where a severe side effect only became scientifically discoverable decades later.
Yeah, they didn't have the tech to see it coming.
Exactly. The law doesn't want to crush innovation by holding creators strictly liable for the scientific unknown. So if a fact pattern explicitly states, nobody could have discovered the defect using the scientific knowledge available at the time, your brain needs to instantly flag the state-of-the-art defense.
Okay, so we've talked about physical defects, slippery floors, exploding kettles. Let's look at legal defects.
Interesting pivot.
What happens when a defendant simply ignores a rule set by Parliament? Can you just magically turn any broken rule into a tort claim? Like, aha, you breached a local health and safety statute, so I'm suing you for a massive cash payout.
Firmly, no.
Yes.
No! You cannot assume that every breach of legislation automatically creates a private civil claim. In fact, many statutes are enforced purely by regulatory fines or criminal penalties, with no civil payout mechanism for individuals whatsoever.
So how do we know if a statute actually gives a claimant the right to sue?
You have to look at the statutory scheme itself. If the legislation explicitly excludes civil liability, then you obviously can't sue in tort for it.
Right.
But even if the statute is silent on the matter, and a civil claim is theoretically possible, the claimant has to pass the WHO and what test?
The WHO and what test? Break that down for me.
Sure. The claimant must fall within the specific class of people the legislation was designed to protect. That's the WHO.
Okay.
And the harm suffered must be the exact type of harm the legislation intended to prevent. That's the what. A famous historical case involved a statute requiring ships to keep sheep in specific pens.
Sheep pens on ships.
Yeah, to prevent them from washing overboard in a storm. Well, the defendant didn't pen the sheep, and the sheep ended up catching a contagious disease from each other.
Ah, so the defendant broke the law, they didn't use the pens, and the claimant suffered harm, the sheep got sick.
But the claimant lost the case.
Wait, really? Because of the what?
Because of the what? The harm the statute was intended to prevent was sheep washing overboard, not sheep catching diseases.
Oh, that's tricky.
If you don't fit both the WHO and the what, you don't have a claim for breach of statutory duty, even if the defendant undeniably broke the law.
Okay, so we've covered individuals hurt by products or places. What about when your whole environment is ruined by a neighbor? Let's talk about nuisance.
Nuisance is often confused with negligence, but they ask very different questions. Negligence is about careless conduct. Nuisance is about interference with land.
Right.
There are two main types, public nuisance and private nuisance.
Let's do public first. This affects a class of the public, right? Say a golf course is built next to a busy public highway, and golf balls constantly fly over the fence onto the road.
A classic scenario.
Lots of drivers are inconvenienced, constantly having to swerve or brake. Can one of those annoyed drivers sue the golf course in public nuisance?
Generally, no.
No, even though they're annoying everyone.
Right. A private individual cannot bring a civil claim just because they, along with everyone else in the community, were annoyed or inconvenienced. That's an issue for the local authorities to prosecute.
So they can't just sue for being annoyed?
No. To sue in public nuisance as an individual, the private claimant must show particular damage beyond that suffered by the general public.
Particular damage. So just having to swerve isn't enough. But if a golf ball actually smashes my windshield and dents my hood as I'm driving by...
Now you have suffered particular damage, a specific quantifiable loss that the rest of the public didn't suffer. That elevates you out of the general public class, and you can bring a private claim.
Got it. Okay, here's where it gets really interesting. Private nuisance.
Yes, this SQE loves this.
They love to test the distinction between trespass and nuisance. Trespass to land is direct interference, right? You physically walked onto my land, or you intentionally threw a rock onto my land.
Yeah.
But nuisance is indirect. The best way I've heard this summarized is, trespass is about protecting your boundary line. Nuisance is about protecting your peace of mind.
That is a brilliant way to frame it, honestly. Private nuisance takes a completely different angle. It asks, has the defendant's indirect use of their land unlawfully and unreasonably interfered with the claimant's use or enjoyment of their own land?
Right.
We're talking about invisible or intangible invasions, noise, smells, dust, vibrations.
And to sue, I actually need a proprietary interest in the land, right? Like, I have to be the owner or a formal tenant. I can't just be a weekend house guest complaining about a smell.
Correct. You need a sufficient legal interest in the land to protect it. And crucially, you have to prove the interference is unreasonable.
Unreasonable.
Right, because the courts don't demand absolute silence from neighbors. We all have to live together. They look at several factors to balance competing interests.
Like character of the neighborhood.
Exactly.
A noisy factory operating in a dedicated industrial park is judged very differently than a factory that decides to open up in the middle of a quiet residential cul-de-sac.
Context is everything. The courts famously noted that what would be a nuisance in a quiet square in London might not be a nuisance in a bustling industrial district.
Makes sense.
If the exam fact pattern gives you descriptive detail about the neighborhood, do not ignore it. It's a massive clue for unreasonableness.
Okay, what if I'm just really sensitive? Say I run a highly calibrated professional audio recording studio in my suburban house, and my neighbor's totally normal, everyday lawnmower ruins my audio tracks.
The law refers to that as abnormal sensitivity.
Abnormal sensitivity.
Yeah, you cannot manufacture a nuisance claim based purely on your own extraordinary sensitivity or the fragile nature of your equipment. Private nuisance protects the ordinary use of land.
Right, it's an objective standard.
Exactly. The standard is what would annoy a normal, reasonable person.
If the neighbor knows I'm recording, hates me, and decides to rev his lawnmower right against the fence at 3 a.m. just to ruin my tracks.
Ah, malice.
Valid.
Yes. If the defendant is deliberately acting maliciously just to annoy the claimant, the courts take a very dim view of that. Malicious behavior can turn an otherwise reasonable activity into an unreasonable nuisance. It is a massive red flag in an exam question.
Good tip. What about defenses? Say the noisy factory says, hey, we have planning permission from the council. Or, we've been operating here for 5 years. You knew we were a noisy factory when you chose to buy the house next door. Are those valid ways to shut down a claim?
Ah, the famous coming to the nuisance argument.
Right.
Neither of those, on their own, are valid defenses.
Wait, really?
Really, knowing about the nuisance before moving in does not automatically strip you of your right to peaceful enjoyment of your land. And planning permission might change the character of a neighborhood over time, sure, but it does not act as an automatic license to commit a nuisance.
That is super counterintuitive, but so important to remember. Okay, so we've covered everyday annoyances. Smells, factory noise. Let's circle back to that wild scenario we started with.
The reservoir.
The massive reservoir, the stranger, the explosion. What if a neighbor brings something so bizarrely dangerous onto their land that it creates an extraordinary risk? That brings us to the final, most unusual tort on the syllabus. Rylands v. Fletcher.
To really understand this rule, you have to look at the history.
Okay.
It was born during the Industrial Revolution.
Right.
The courts were trying to balance the needs of massive new industrial mills against the rights of traditional rural farmers.
Right.
They decided that if you are going to undertake an extraordinary risk for your own benefit, you bear the cost if it goes wrong.
So it's another form of strict liability, but highly specific. What are the ingredients?
There are 3 main elements. First, the defendant brings or keeps something on their land that is likely to cause mischief if it escapes.
Like what?
Large quantities of water, hazardous chemicals, explosives.
I got it.
Second, the defendant makes a non-natural or extraordinary use of the land. It can't just be a domestic water pipe. It has to be special, unusual, or extraordinary in the circumstances.
And third, the dangerous thing must escape from where it was accumulated and cause foreseeable damage.
Exactly.
I want to lock in a mental framework for this for everyone listening. Bring it, store it, lose it.
I love that.
You bring a dangerous thing onto the land, you store it in a non-natural way, and you lose control of it because it escapes your boundary. Bring it, store it, lose it.
It perfectly captures the chronological flow.
Oh.
But let's answer your opening question about the saboteur.
Right. Strict liability does not mean absolute liability. We learned that with defective products.
Exactly.
So if my neighbor has that massive reservoir, a non-natural use, and some random stranger breaks in and blows up the dam, flooding my house, is the neighbor strictly liable for the saboteur's actions?
If we connect this to the bigger picture of strict liability, the answer is no. Rylands does not mean the defendant pays for literally everything.
Okay.
The damage must be reasonably foreseeable. If an unforeseeable act of a stranger, your malicious saboteur, causes the escape, or an unforeseeable natural event like a freak earthquake occurs, the defendant has a valid defense. The chain of responsibility is broken by the unforeseeable intervention.
Wow. Okay, so what does this all mean for you as you sit down to tackle your SQE revision? It means scanning the fact pattern for the clues that unlock the law. Let's recap.
Let's do it.
If the scenario gives you a wet floor in a commercial space, think Occupiers Liability, the 1957 Act for lawful visitors. If someone is sneaking over a fence onto a construction site, think the 1984 Act for trespassers, and remember it only covers personal injury.
Right, and if you see a defective toaster, a collapsed ladder, or an exploding kettle, think product liability. Determine if they need to use ordinary negligence or if they can rely on the strict expectation test of the Consumer Protection Act.
If an entire community is disrupted, but one person suffers particular damage, like the golf ball smashing a windshield, think public nuisance. If it smells or noise interfering with a neighboring landowner's peace of mind, think private nuisance.
And if an incredibly dangerous substance escapes from land after an extraordinary use, think Rylands v. Fletcher. Bring it, store it, lose it.
Yeah.
The ultimate exam technique here is to stop asking, what tort is this? And start asking, what specific fact is the examiner trying to make me notice? Recognize the trigger, identify the claimant, and applying the law becomes just a logical progression.
It's all about being the detective at the scene of the crime. As you dive back into your notes, I want to leave you with a final thought to ponder.
Go on.
Think about that non-natural or extraordinary use requirement in Rylands v. Fletcher. The law balances industrial progress with safety, right? But as technology rapidly evolves, what happens when something that is considered a bizarre, extraordinary danger today, maybe, I don't know, a high-capacity lithium battery storage unit in a residential garage, becomes a totally normal, everyday household item tomorrow?
Wow.
How will the strict liability of Rylands adapt when the extraordinary inevitably becomes the ordinary?
That is a fascinating question of how the law breathes and shifts with human progress.
Something to mull over while you study. Good luck spotting those triggers. You've got this.